דין הוא קיבל, הוא למד משפטים בעיר מולדתי, שיקגו, אילינוי, בנורת'ווסטרן יוניברסיטי, שזה מאוד קרוב אליי. ואחר כך נחזור עם סטוארט, הוא יתייחס לשינויים בדרך של הרפורמה, ואיך זה יכול להשפיע על הקמת מבנים לצורך מס וגם משפטי בארצות הברית. אז ניקח כמה דקות, אני אזמין את ג'קי וסטוארט וג'ודה לקחת כמה שאלות על הפרזנטציה שלהם, ואז נעבור לצד רוחני. יש לנו מרצה מאוד מיוחד, גור שומרון, ידיד נפש שלי, חבר טוב, שידבר על משהו קשור למסע, להקים חברת הייטק ומה זה קשור. אני אתן עוד מילים אליו שאנחנו נגיע להרצאה שלו, זה פשוט משהו מאוד מעניין. אז ג'ודה פיש, אתה מוזמן לדבר על נושא, סליחה, אני אכתוב, זה Excluding Stock Based Compensation from your cost plus נושא מאוד חם בזמנים האלו.
There are many people here today with different levels of experience with transfer pricing, so I wanted to give sort of a peek under the hood into one corner of one area of transfer pricing that currently right now is in a state of flux, specifically in the United States but other places as well. So let's say you're an Israeli company. For some of you, that's the case, you are an Israeli company, and you enter into an agreement with a U.S. company to do sales and marketing on your behalf. Not a company that's your subsidiary, an independent company that you found through Google. So you make an arrangement with them to do sales and marketing on a cost plus basis. Let's say cost plus 3%. So let's say you receive the following invoice. Is this something that you were expecting? So you see on the costs, wages, stock-based compensation granted to their employees, meals and entertainment, travel and other expenses for 100, plus the 3% for a total of 103. So many Israeli companies would be surprised to see this invoice because it includes the stock-based compensation of the U.S. company. Why would you want to pay the stock-based compensation, meaning the cost that that company incurred to give stock options to their employees? What does that have to do with you and your company in Israel? Well, what could that cost be? That cost, although yearly is 10, but the way it's calculated as an expense for the U.S. company is the difference between the spread at the time of exercise, meaning the exercise price that the employee pays versus the fair market value of the stock at the time of exercise. So if the stock goes up in value, that could be a huge expense for that company, and then they want you to pay that as part of the cost plus arrangement. So why would I do that? That's a big liability for me, and it doesn't make sense, ma'akish. So as the government attorney said, actually this is a taxpayer attorney in the court case that we'll speak about a little bit later. Play the clip.
No one in their right mind would share stock-based compensation.
No one in their right mind would share. So let's look at an example of how the taxpayer would prefer to see it. The taxpayer would, let's say you have here, this is an example of related companies. You have an Israeli company with a U.S. subsidiary. The U.S. subsidiary is doing sales and marketing on behalf of the Israeli parent company, and the Israeli company is making direct sales to customers. So the Israeli company pays the U.S. company on a cost-plus basis for its expenses. So the U.S. company would like to show the tax return like this. They have expenses of 100 they have a cost plus arrangement, so they have income of 3, and then they take their stock options that the U.S. company granted to their employees, which is 5, and then they have a net loss, so they don't pay tax. That's how the taxpayer would want to see this invoice, which means that you could keep more money in the Israeli company, and Israel has a lower corporate tax rate, so it's beneficial for the taxpayer. The IRS, on the other hand, would want to see the tax return like this, that the U.S. company has expenses of 100, plus they have a stock option expense of 105. And on a cost plus basis, that's 108, approximately. And then they would have taxable income of approximately 3. So that's how the IRS would want to see that instead of having a loss, the U.S. company would in fact have taxable income. So what do? The taxpayer says one thing, the IRS says another. So let's let transfer pricing decide. That's what it's for. So there's a case in the United States right now where this company called Altera it's now a subsidiary of Intel. They had a U.S. company, they set up a Cayman affiliate and licensed intellectual property from the U.S. company to the Cayman affiliate to generate income from on licensing that technology to customers outside of the United States. But they also entered into a cost-sharing arrangement to develop the intellectual property. So the United States company, the Inc., had stock-based compensation. And so in the cost-sharing arrangement, so you would maybe think that they should share them, that's what the IRS thinks. But the U.S. company said, we're not including in our cost-sharing arrangement the stock-based compensation. And they disclose that on their tax return. There's a special form. If you disagree with the regulations, we'll see the regulations soon, that say you need to do something. If you disagree and think the regulations are wrong, you can take that position on your tax return, but you need to file a form and disclose that to the IRS. They basically said to the IRS, come and get us. And so the IRS came to get them. So the basic law of transfer pricing in the United States is Section 482, and was enacted in 1928. And it says that the Secretary of the Treasury, the IRS, can allocate income so that to prevent evasion of taxes. So they can allocate income between companies, typically related companies, to make sure that nobody's evading taxes. This has been known, at least since 1935, as the arm's length standard. What two parties negotiating at arm's length, meaning not related parties, would do. Now, Congress was worried that some related parties would enter into a transaction for intellectual property, and they would allocate the income in a certain way when the value of the IP was very low. And then years later, when the IP value would explode, the allocation didn't seem fair, and the U.S. wasn't getting enough money. So they added the second sentence that says that in the case of any transfer or license of intangible property, that the income with respect to such transfer or license shall be commensurate with the income attributable to the intangible. Now, that sentence right there is hard to understand for anybody, I think. So what it basically means is that the transferee and the transferor need to share proportionately in the income. But that, and what the IRS interpreted from that is that basically if you enter into an agreement with a related party to allocate income for a certain intellectual property or intangible property, and years later the values look to the IRS disproportionate, they can go back and readjust the amounts and allocate income as they think it should be. So that right there is a controversial statement. That's a controversial position, a controversial law, because do unrelated parties, when they make a deal, and then one side ends up making more money than the other, do they go back and renegotiate and say, well, it's not fair, even though at the time we thought it would be worth this, and now it's worth a lot more, so we get more? Do unrelated parties do that? So the answer is yes, sometimes it happens, but it's not very common. But the IRS nevertheless said that's what this sentence means, and we can go back and we can readjust the income. Now, many of the United States treaty partners, other countries, got nervous because they said, wait, I thought arm's length standard, I thought that was the standard, and here you are saying that you're going to do something that arm's length parties don't do. So the United States came to other countries and said, no, the arm's length standard is still the standard, don't worry about it, this means we still need to look at comparables and look at what other non-related parties are doing. The arm's length standard is still the standard. The regulations to Section 482 explain the purpose of the law, and they say that the whole purpose of Section 482 in transfer pricing is to place a controlled taxpayer-related parties on tax parity with an uncontrolled taxpayer. We want to put related parties in the same place that unrelated parties would be. So how do we do that? We look at what unrelated parties would do. We look at contracts, we look at pricing that's out there in the real world. And then the regulations also say that in determining the true taxable income of a controlled taxpayer, the standard to be applied in every case is that of a taxpayer dealing at arm's length with an uncontrolled taxpayer. Every case needs to be arm's length, which means you need to look at what unrelated parties are doing in the real world and use that when you're trying to figure out how much income related parties should have. Now, the regulations then say later there was an amendment and the IRS added this part that we told about based on the commensurate with income standard. And they said that when you're doing a cost-sharing arrangement, it's only going to be considered arm's length if you include stock-based compensation. The costs of the options that the companies give to their employees, they need to share that too. That's the only way it'll be arm's length. And that's where the taxpayer took issue, because he said, if the whole point of transfer pricing is to put related parties in a place where non-related parties would be, how could you say that we, related parties, need to include stock-based compensation? Unrelated parties never do that. So how is that arm's length? It's a contradiction. You're telling me we need to be arm's length, what non-related parties do, but we also need to include stock-based compensation with unrelated parties never do. So how does that make sense? So they pointed out in the litigation that even contractors, when the United States federal government enters into a contract with a contractor on a cost-plus basis, do they include stock-based compensation? No, they do not. In fact, the law says they're not allowed to. The federal government is not allowed to include stock-based compensation in the cost that they reimburse contractors for. So the taxpayer said, look at unrelated parties, no better than the federal government itself doesn't do this. So why should the taxpayer need to do this? The IRS said, even though unrelated parties don't do it, related parties need to do it, and that's arm's length, because we said so. Again, it doesn't seem to square. The IRS took different positions in litigation. At one point they said, it is arm's length, and when we look at comparables, that's what they told the treaty partners, and then they said, no, we don't need to look at comparables, it is arm's length, it's whatever we decide it is, and it's a term of art, and we can say what arm's length would be in this situation. The taxpayer said that you can't just make that up. I mean, we saw in every case, the arm's length standard is what has to be used in every case. So there seems to be a contradiction in the regulations. And then they said, and you know what? We saw that it said in the transfer of intellectual property, transfer license of intellectual property. But they said, we're not doing a transfer. We're doing a joint development project, a cost-sharing arrangement. So there's no transfer of intellectual property. So I said, well, transfer doesn't really mean transfer in the traditional sense of the word. Transfer is broad enough to include other types of transactions as well. That's what they said. So according to the arm's length, according to the IRS, arm's length doesn't mean what other unrelated parties are doing necessarily. It means what they say. This is the government lawyer in the case.
The IRS had taken the position since at least as far back as 1997 that in the cost sharing context, all costs means all costs, and that's what the 1986 conference report said, and that's what we're following. And the fact that you can come up with evidence that shows that unrelated parties in similar types of arrangements would not agree to share the cost is irrelevant in this context.
Okay, so arm's length and comparability don't go hand in hand.
Correct. That's yes. They do not. I mean, there is certainly comparability analysis is a very important means to the end of getting to an arm's length result, but they are not. They do not go hand in hand. I mean, you can have.
You're arguing they're not synonymous.
Exactly.
So it's like, it's a little uncomfortable to watch because he's struggling with the concept that arm's length, and you don't need to look at what real parties do. So the judges luckily helped him out. That oral argument actually was, I think this is in October. So this was last month. This was in front of the Ninth Circuit Court of Appeals after the government lost in the tax court. The tax court ruled in their favor, then it went to a full panel, and they lost 15-0. And now it's at the Ninth Circuit Court of Appeals. And so that was the government's argument, part of it. Can you do the next slide? And can you push play again? This is the taxpayer part.
So you can't have something that doesn't even look at reality to ultimately impose parity between controlled and uncontrolled parties, which the Supreme Court thinks is the purpose of the statute. Treasury thinks it's the purpose of the statute. They haven't taken that regulation off the table.
And then the taxpayer argued this.
What we have here is the weakest possible application of the statute and the strongest possible rule on the weakest possible administrative record and the strongest possible rule. This is arbitrary decision making, and it's a poster child for arbitrary decision making.
I'm not sure what he said there. I thought I understood it, and then he kept going, and then I lost him, and then I watched it a few times, I still don't really get it. But I think he's making a good point. So, does it only apply to cost sharing arrangements? Let's say we're not developing IP. Let's go back to our example where we're an Israeli company with a U.S. subsidiary doing pre-sales and marketing. And do we need to include stock-based compensation there? That's not what the court was dealing with here. But, in fact, the IRS said yes. Even in a services transaction, like we talked about, you need to include the stock-based compensation of the company performing the services in your cost plus. So the IRS took this law that's in commensurate with income, and they said arm's length is whatever we say it is. In cost sharing, where there's a license or transfer of IP, it doesn't necessarily have to be a license or transfer of IP. And you know what else? It also applies in services transactions as well, when one party is doing services for the other one. So what's next in this case? So we're waiting for the ruling from the Ninth Circuit, and either they'll void the regulations or they'll uphold them. Part of the argument in the court revolved around, even if the IRS is right, if they can decide what arm's length is, did they go about promulgating the regulations in the right way? Did they issue notice to interested parties and receive comments and then deal with them in the right way? So if the IRS if the court voids the regulations, the IRS might have to go back and try again to pass these regulations, which might be harder to do now. Congress might have to get involved and actually make a law that you need to include stock-based compensation. So they say that litigation and sausages are in common because they're two things you never want to see how they get made. So until that legislation actually gets made, it may get ugly. Now, one of the arguments, though, was that the U.S. treaty partners would not be happy with this idea that you need to include stock-based compensation because it goes away from the arm's length standard of the treaties. But in Israel, there was a case recently, the Caltera case, where the Israeli court said that yes, the taxpayers need to include stock-based compensation. That case is on appeal here in Israel, I believe. But it's not so simple that the United States is the only country trying to take this approach. If other countries do as well, some countries do, some countries don't, what does that do to the treaties? It may be a political issue more than a legal issue. So then, what can be done now? If a company has been including stock-based compensation and then this regulation is overturned, can they file amended returns with the IRS, amended tax returns to get that money back? It's not so clear that you could do that because transfer pricing typically has to be done only on a going forward basis and can't be used to look backwards. But some companies, since these regulations were put in place, they realized that they might eventually get overturned. They put in their contracts and their intercompany agreements a clawback provision that says that if these regulations are overturned, we're entitled to get that money back. So if these regulations are voided, a lot of companies may be doing that, and then they might take what says of their advance credit, they might just consider that a credit for future years. The money that we think you in prior years we don't really owe you, so future years we'll just have a credit going forward. Another thing they could do is potentially all the treaties basically have something called the mutual agreement procedure, where it says that the two countries' tax authorities need to come together and work out a solution if there's any issues under the treaty. So potentially, let's say an Israeli company could go to the Israeli tax authority, the Israeli government, and ask them to get involved with the United States now that these regulations are voided to try and get some of that money back. Will that happen? Is that likely? It's hard to say, but it would be surprising if that happened. In the meantime, what a company could do if they're facing this issue, we have a client now that's an Israeli parent company with the U.S. subsidiary, the CEOs in the United States, and getting stock option compensation. But if they had to include it, it would put the U.S. company in a profitable position and they owe a lot of taxes. So a company could take a position that these regulations are invalid, like the tax court has already said. They'll disclose that on their tax return to the IRS, supported with a tax memo, which we're helping the client with, and they could not include the stock-based compensation. This particular client could save probably $100,000 by taking this position. And it's something that we are in discussion with other clients as well. Okay, this was a brief presentation about one area, one corner of transfer pricing. It's a very complex field and very broad. The regulations themselves are, as the government said, 100 pages, single-spaced. That's a lot of regulations. But we're here with Jackie and Stuart. We're available if companies need assistance in structuring their intercompany arrangements. Give us a call and be in touch.